I will call the Committee on Civil Law and Data Practices to order. Welcome, everyone. We do have a quorum present. Representative Vogel would like to move the minutes from March 5th, 2015. Any discussion on the minutes? Seeing none, all those in favor of approving the minutes of March 5th, please signify by saying aye. Aye. Opposed, same sign. The minutes are adopted. The first item on the agenda is House File 518. And I will go to the testifier's table for that. Mr. Chair?
Yes, Representative Scott.
It appears that I left my family law file upstairs on my desk, so I'll try to wing it from here. House File 518, actually, yeah, maybe I will just take that folder. I can wing it. Okay, House File 518 is a bill that we have heard in the committee before, and we did lay it over. Now we'd like to go ahead and move it forward, so I'd like to move House File 518, and I believe is it going to the General Register or to Public Safety?
Public Safety.
Okay, I'd like to move that bill be re-referred to the Committee on Public Safety. And just as a reminder to folks on the committee, this file, or this bill is a product of our custody dialogue group. This particular bill clarifies the parenting time of a 25% minimum presumption. And that bill, or that law, came into effect about 8 years ago. And since that time, it seems that that has been, the 25% has been used in many courts as a floor and not a ceiling. And so we just, if you take an analogy of a speed limit on a freeway, the minimum being 45 miles an hour, very few people are going to actually drive 45 miles an hour because that is the minimum. So we want to just to make a little tweak in the language that clarifies that the 25% is to be seen as a floor. Or actually, let me back that up, that it was seen as a ceiling and not a floor. So that is a minimum. So we tweak that language to a minimum of 25%. The next section of the bill talks about compensatory time, parenting time, when one parent has been denied parenting time by the other, the court-ordered parenting time. And it also establishes there towards the end of that section civil penalties for continued, let's see, the language is repeatedly and intentionally denying court-ordered parenting time. So there are some civil penalties there. The next section basically says that in a post-decree stipulation, parties can reach an agreement on their own, a private agreement. Oh, and the next section, Section 4, talks about providing income information. And if this just says if one party is supposed to give the other party a copy of the income tax return and they don't have the return finished or they haven't filed, that they do have to give the supporting documents to that tax return to the other party. So a party's 1099, W-2, K-1, those sorts of things would have to be supplied. So I believe that encompasses the bill. Actually, I got the one out of order that talks about the alternative. Oh, actually, no, I didn't. The alternative effective date is the last section of the bill. That normally when you're going into court for, I believe this applies to modification only, is that right? Yes, okay, so only when they're going back in for a modification. Normally, the date that the papers are filed is the effective date, but this is just saying that the parties can agree to a binding agreement of a different effective date. And with that, that's the summary of the bill, and so I would just take any questions that members might have.
Representative Hillstrom has a question.
Thank you, Mr. Chair. Representative Scott, I see that in the remedy section, you are giving a remedy for when one parent withholds the child from another. What's the remedy when one parent continues to not show up to pick up the child when it's their date and time, and at the last second, the parent who has primary time ends up having to find alternative plans, or ends up having to arrange for childcare, or ends up having to put out additional dollars based on the failure of that parent to actually comply with the parenting time schedule?
Representative Scott.
Thank you, Mr. Chair and Representative Hillstrom. I believe that's already in current law, but I'll let Mr. Dreckberner answer that question.
Mr. Chair, Representative Hillstrom.
I'm sorry for interrupting. Please state your name for the record.
Sure. My name is Michael Dittberner. I'm the legislative chair for the Minnesota chapter of the American Academy of Matrimonial Lawyers. Representative Hillstrom, I have practiced family law for 30 years. Generally, when I'm faced with that type of situation, as are many of my colleagues, we'll try to address that through seeking relief from the court to, I guess, sometimes have financial sanctions against an individual who places somebody in that predicament, who has to make alternative arrangements for child care because somebody chose not to exercise the parenting time. We didn't include that in this particular bill as an item of relief, but this bill, I believe, is fair to both custodial parents and non-custodial parents, to fathers and mothers of whether they're custodial or non-custodial, because I think it not only does it provide additional enforcement remedies for denials of compensatory parenting time, but it also takes into consideration the impact on the children and whether or not there might be a defense to a request for compensatory time and other sanctions in the event that it is believed that parenting time would not be in a child's physical or emotional health. So we had a broad-based group of people that were working on this. We haven't dealt with that particular issue in this legislation, but I really don't think that there was as much of a need perceived by all the different stakeholders that were involved in our group to have specific legislative provision regarding that issue and addressing it.
Representative Hillstrom.
Thank you, Mr. Chair. Well, Representative Scott, I understand that this is part of a working group process, and you all came to some consensus around some of these issues. But I think if you're putting penalties in, you should be putting penalties in for both sides of the bad behavior. I don't think you should be saying it's not okay if you withhold, but it is okay if you fail to show up when it's your time. Because if you have someone who continues to fail to show up, and then the one time the parent denies, they're being brought in for penalties and remedies, right? It's just another way to continue to bring somebody back to court, back to court, back to court. And you ought to be able to have the ability to balance both sets of bad behavior.
Representative Scott.
Thank you for those comments, Representative Hillstrom, and I'll certainly take that under advisement. Again, it didn't even come up in our group, so I'm not sure that that's something that we can address this year, but in the ensuing years, it doesn't seem like it would be a problem to talk about that.
Any other questions or comments? Seeing none, Representative Scott renews her motion to have House File 518 be re-referred to the Public Safety and Crime Prevention Committee. All in favor say aye. Aye. All opposed say nay. The ayes have it. House File 518 is re-referred to the Public Safety and Crime Prevention Committee. On to House File 497.
Thank you, Mr. Chair. And I don't know if there's somebody from the counties here to testify on this. House File 497 was brought to me by the folks at Anoka County. Several counties have come to the table on this, and they just want to make some clarifications as far as income withholdings when it applies to back arrears child support, and so I'll let the testifier explain it in further.
Good morning. Welcome to the committee. Please state your name for the record.
Yes, Chairman, my name is Ward Innes. I'm here on behalf of Anoka County, and I think Chair Scott accurately portrayed the bill. Basically, right now, we have a conflict in the child support arrears area if there's a court order and the statute. The statute requires us to withhold 20% of the outstanding obligation that's owed, but if we have a court order that contradicts that amount, we have to put the court order into the system, and then we have to add the 20% onto that amount. The system requires that. So this would allow us to not do it. Then we have to do a manual workaround, essentially. And every county has a different process for doing this manual workaround. So really, this is about efficiencies, making sure when we have a conflict between a court order and the statute, which requires 20%, we can just do the court order, plug that into the system, and not have to do a manual workaround in order to get the appropriate amount to the child support, person who's owed the child support. And this is supported by the Minnesota Association of County Social Service Administrators. It's also been endorsed by the Minnesota Family Support and Recovery Council.
Any questions? Comments? Representative Hillstrom.
Thank you, Mr. Chair. Do you believe that taking this 20% out of the statute then will result in the majority of orders then being less than 20% going forward?
Mr. Innes.
Chairman, Representative Hillstrom, in fact, we're not going to take the 20% out of the statute. What it will do is that when there is in fact a court order, the court order is the amount that'll be. So in all other instances, when there's not a court order, it would be the 20% still. So it's only when there's a conflict between the 20% that's in current statute and a court order that's issued.
Mr. Chair.
Representative Hillstrom.
Thank you, Mr. Chair. And it doesn't impact the judge's ability to go over the 20%?
Mr. Innes.
Chairman, Representative Hillstrom, exactly, precisely. That's correct.
Mr. Chair.
Representative Hillstrom.
Thank you, Mr. Chair. And so if the court order is for 40%, but the statute says 20%, does the person who's been ordered to pay the 40% have the ability to say, well, wait a minute, the statute only says 20%?
Mr. Innes.
Chairman, Representative Hillstrom, it's a very good question, and the court order will always trump the 20% in the statute. So that's, yeah.
Any other questions or comments? Seeing none, Representative Scott renews her motion to have House File 497 be re-referred to the General Register. All in favor say aye. Aye. All opposed say nay. The ayes have it. 497 is sent to the General Register. On to House File 155. Representative Scott?
Thank you, Mr. Chair. House File 155 is my bill on license plate readers. It basically says that unless there is a hit on the license plate reader, that the data would not be kept, it would be destroyed. And with that, I would guess I would take questions. There are some requirements in there for law enforcement to maintain a log of its use for things such as locations where the reader is installed or used, specific times of day that the reader actively collected the data, and aggregate number of vehicles or license plates on which the data are collected for each period of active use. I'm guessing since this is the third time we've heard these two bills, or this bill anyway, that members are fairly familiar with how it works.
And Representative Scott, let me start by saying that I move to have House File 155 brought before the committee, and also I move that your bill, House File 155, be re-referred to the Public Safety and Crime Prevention Committee.
Mr. Chair.
Thank you.
Representative Hillstrom.
Thank you, Mr. Chair. I'd ask for a roll call vote on this bill.
All right, and before that is noted, Representative Hillstrom, before we get to that, there are some testifiers. If there's any testifiers, would they please come forward? Yep. Mr. Newmeister, please come forward.
He's confused.
Apologize. I'm just bringing in the testifier who is ready.
Thank you. Welcome to the committee. Please state your name for the record.
Thank you, Mr. Chairman. Matt Ealing with the Minnesota Coalition on Government Information. Apologize, we were delayed in the hallway momentarily. I'm here to testify today on behalf of HF 155, and I'll provide a two-part analysis that outlines why this bill provides the best resolution to the issue of license plate reader regulation. The first part of the analysis involves looking closely at what LPR technology provides, and it's our organization's position and belief that the policy that guides the use of government technology, especially technology that collects data on individuals, should be narrowly tailored to meet a specific purpose. As you've heard, LPR allows the automation of a formerly manual process of checking vehicle plates against existing police databases for open warrants, stolen vehicles, and the like. Industry literature speaks to this capability, as does the testimony that you've heard in recent weeks. It's clear that using LPR to generate hit data that correlates to plate images or existing law enforcement leads provides a public safety benefit. The use of LPR for a specific and limited purpose should be supported, and HF 155 enables this specific purpose and would convert hit data to private or non-public status for subsequent use by law enforcement. As this committee has also heard previously, LPR generates a byproduct of data, non-hit data, data that does not correlate to information in police databases, and this data contains the location of vehicles and thus individuals that are not related to existing law enforcement operations. This non-hit data accounts for the vast majority of LPR data, and its existence triggers the second part of our analysis. Non-hit LPR data has generated the bulk of the discussion and debate in this discussion so far over LPR information, and we believe that the answer to regulating this sort of data is found by looking to our nation's history and tradition. The American legal system has a long-standing tradition of limiting the collection and maintenance of data on individuals unless that data has an identifiable law enforcement purpose, as opposed to merely a possible or speculative purpose. We see this in the Fourth Amendment's calls for specificity in warrants, as opposed to the open and general warrants of the British Crown. In the 1960s, when the first federal wiretap laws were written, minimization procedures were put in place so that non-pertinent telephone conversations heard through wiretaps were not collected or archived. Likewise, in the 1970s, the U.S. Attorney General instituted procedures under which the FBI could only open investigations and gather data if a criminal predicate was first met, expressly limiting the FBI's ability to gather data and maintain data that was not relevant to a criminal investigation. The advent of mass collection technologies, whether LPR or other techniques, have begun to place strains on this long-standing premise. Such technologies allow larger and larger data sets to be gathered on the public in general for possible and speculative purposes, rather than focusing specifically on suspected or known lawbreakers. And this has caused a rift to develop between our tradition and our technological capabilities. And today we'd urge this committee to cast its vote on the side of tradition. Since this debate started 3 years ago, we've supported the idea that non-hit data should be kept only as long as necessary to technically separate the hit data from the non-hit data, and this bill accomplishes that purpose by keeping hit data and discarding the non-hit data thereafter. Finally, and most importantly, it's worth noting that the debate over non-hit LPR data is bigger than just this single technology. With LPR, the Minnesota legislature will be establishing for the first time how it will treat data from mass surveillance technologies, including drones, facial recognition, and more. What's decided this session will have long-range consequences and will set the baseline for the future relationship between the government and its citizens in the realm of technological surveillance. And we believe this bill sets the correct and appropriate precedent for these consequential matters, and we urge you to support it. Thank you very much.
Any questions? Representative Hoppe.
Thank you, Mr. Chair. It's an easy question. I'm just wondering, sir, if you could repeat the organization you're with. I didn't catch all of it.
Oh, certainly, sorry. Minnesota Coalition on Government Information.
On governmental information. Thank you.
Thank you.
Representative
Apologize for being late.
Representative Lesh.
Thank you, Mr. Chair. Mr. Ailing, can you tell me Where's the prevailing trend with states overall in the direction they're going with the amount of time they're retaining non-hit data currently?
Currently, Representative, many states have taken a longer time frame for retaining LPR data. We believe that's going in the wrong direction, and we would like to see Minnesota take the lead in shortening that retention time frame for non-hit data, data that's not relative or relevant to an ongoing investigation.
Well,
Representative Lesh.
Mr. Chair and Mr. Ailing, I've heard about recent states, and I can't even recall it right now, but doing a 15 days and lower. Previously, in previous years, I had heard longer, but when I'm talking about more recently, in the last few months or the last 6 months, I've heard of shorter times. Am I incorrect on my understanding of that?
Mr. Ealing.
Representative, there is one state that recently passed a 7-day retention, so that was a more recent, that's a state out east that I can't recall off the top of my head, but it is one of the shorter retention periods that has been passed, and that is a more recent instance.
Okay.
Representative Lesh.
Mr. Chair, Mr. Ealing, a few years ago, there was a commercial on television where there was a voiceover, and it showed Officer Friendly driving through the streets, kind of keeping an eye on the neighborhood, and there was a burglar getting ready to rob something. And it panned back and forth from one scene to the other, and the voiceover was explaining how law enforcement is developing more tools to track crime, and not only are they developing more tools to track crime, but actually prevent crime before it happens. And at the last scene of the commercial, there was this burglar coming around the corner of a 7-Eleven or something to rob it, and there was Officer Friendly leaning up against the hood of his squad car with a cup of coffee, and the burglar kind of slunk back around the side of the building and didn't even try anything. Victory for law enforcement. The commercial offered to trump at the values of actually anticipating crime, prevented it before it happened by being able to track behavior. What is wrong with that as an effort, and does this bill get in the way of that?
Mr. Ealing.
Thank you, Representative. The tracking of possible crime, say the filing of suspicious activity reports, that's part of intelligence data in other states, that has at its base some connection to suspected criminal activity. Someone has observed something that's unusual, they file a report about it. The difference with this is that this is mass surveillance of all activity going on. Unconnected, there's no baseline connection to anything even being unusual or out of sorts. And so if you're keeping all of that non-relevant data in the hopes that someday there may be criminal activity associated with it, there is no logical way to stop that once you start down that line. Once you say we're going to collect data that's not relevant to any criminal activity, but might be in the future, there is no logical stopping point. And so that's why we're very, very focused on making sure that hit data is maintained, non-hit data is destroyed.
Representative Lesh.
Thank you, Mr. Chair. And Mr. Ailing, let me give you an example. Let's say there's, during session, some big fundraiser for Ziggy Wilfs or something when he's building the stadium, okay? And the public's concerned that the legislature's going to be colluding to give a team owner a lot of money for a boondoggle. I can't imagine how that'd happen. But let's say someone decides to park a squad outside the SOB ramp when there's a fundraiser going on and tracking when legislators are coming and going and keeping tabs on legislator. There could be criminal activity going on there. What would be wrong with that?
Mr. Ealing.
I think our tradition leans on, to the degree that you can identify specific individuals and track those individuals and gather data on those individuals, that's the threshold from which you begin. And to the extent that we can minimize the gathering of indiscriminate data, even if there's a speculative purpose, we would urge that that is the dividing line in the definition.
Okay. Thank you, Mr. Chair.
Any other questions or comments for this testifier? Mr. Representative Johnson.
Mr. Chair, I'm a little concerned on the zero retention. I've talked to a lot of different departments, a lot of different officers on how these license plate readers are used in certain circumstances. If there's a kidnapping or a child abduction, the license plate readers, if if there's a car, if there's a squad that can respond to the scene that does not have a reader, they do that. The squads that have the readers, they go out and patrol the area. They're grabbing license plates for the investigation, see who's in. So when they do have a suspect, they can check to see if that vehicle was in the area. Now with this bill, it does not allow that. I'm concerned about those kids. I want to get those kids back safe. And it's a good program to do that. So I have a lot of reservations on this bill because it cuts off the arm of law enforcement to do their job to protect us. So I think, I know you're concerned about the data that's stored. I think the way to do that is more on policy and procedures, how to look at that data. Not just destroy it, but how to look at it in a proper way that meets the requirements for the standards to protect that data. And if there's violations with people inappropriately looking at that, if it's in policy that they can't do that without the proper authorization, then strict discipline and repercussions can occur to them immediately. But if you put it in statute and make it law, it could take 3-4 years before it gets into court and a guilty verdict. And some of these cities, counties, or even the state might be paying these people 3-4 years of salary while they're not even at work because they're on administrative leave. So I think we have to look very closely at how we do this and make sure we do it right. Because we have two constitutional issues, protecting people's rights and protecting their safety. And we have to make sure we do this properly.
Mr. Ealing?
Respectfully, to respond to your concern, the concern that we would have with putting this information in a lockbox and then granting access to it is that you start going down the road of the arguments that the National Security Agency has made, for instance, where they want to gather all of our telephone metadata, keep it in a lockbox, and then say, well, under our reasonable suspicion standard, that's when we can start accessing it. But it starts to break down this tradition where we have generally not gathered information on people that there's no relation to criminal activity. And certainly, if we gather all the information that we are now technically capable of doing so, you might be able to find bad actors, you might be able to find instances of criminal activity. That is certainly the case. Just statistically, if you gather all that information. We're again concerned about the logical breakdown of a long-standing tradition.
Representative Johnson?
Yeah, I understand that, but I also have to look for the safety of these kids and these victims. Because I don't want to cut off an arm or a tool that could be valuable in getting them back safely. So like I say, we have to look at it very closely and make sure we do this properly, and in some cases make there an exception to the zero, if we go with zero, for those investigative purposes, for the safety of the citizens of Minnesota, if it deals with a criminal activity trying to, like in a kidnapping, get that person back safely.
Mr. Ealing?
No, I think we will agree to disagree on that point.
Any other questions or comments for this testifier? Representative Lesh?
I had a question, Mr. Chair. You know, if there's a kidnapping, Representative Johnson, that would certainly fall under the gamut of probable cause, would it not? I mean, if someone was kidnapped and it was the child's father or something, there would certainly be probable cause to track that individual's license plate location.
Representative Johnson?
Mr. Chair, Representative Lesh, the problem is you wouldn't have probable cause that the information would be in the system. So that's where the problem is. You'd have to know it's in there to be able to look into it.
Well, and Mr. Chair,
Representative Lesh.
Representative Johnson, you know, I understand that. And I think where we've run into problems in the past is for about 3 years now, I have offered law enforcement an opportunity to negotiate based on that point. And I have essentially been met with stonewall. Nope, we're not going to talk about, we need this information. And I've met with the same talking points you just offered. No, this is really important to protect our kids. And I said, okay, every scenario that's been given, there would have been probable cause or at least reasonable suspicion to broach that. But in light of the lack of cooperation, there's no reason for us to go down this road, because the tradition that Mr. Ailing talks about is exactly right. It is a critically important tradition of this country that we don't track people. They make movies about this, Minority Report and all kinds of things, and, you know, you can say they're ridiculous, but people said that all kinds of things were ridiculous in the 40s that we're doing now. And it's important to remember that when we break this kind of contract that we have with the people, we need to be accountable for it. So, by the way, we don't know what you're doing wrong. And when I had the Minneapolis Chief of Police sitting in here, and I asked her, what kind of crime do you think I'm going to do in the next 60 days that you don't know right now? Why do you need to track my location for the next 60 days? And she said, well, Representative Lesh, because we don't know what we don't know. That's not a good enough reason to track innocent people. It's just not. So the speculation about the things that could go wrong, you're absolutely right, and you're accurate. But that requires that law enforcement come forward with some kind of individualized justification. But they don't want to do that. They say, nope, we don't know what we don't know. Therefore, we're going to track all of you. At this point, 0 days is reasonable, absent some kind of good faith effort on the part of law enforcement to offer why they need to track innocent people. So, just my soapbox. Thanks for listening, Representative Johnson.
Representative Hillstrom.
Thank you, Mr. Chair, and I just wanted to counter a little bit to Representative Lesh. I was on the conference committee in the last biennium when they couldn't reach agreement. And I asked one of the questions of both sides and said, so you've had a license plate reader in a parking lot where a rape took place. Doesn't the defendant want to know all the people that were in the area as well so that he could have information to potentially exonerate himself if he isn't guilty and he's the one that's charged? And if you don't keep the hit data, you actually may be destroying exoneratory evidence that the defendant didn't do it. Or maybe there was someone else who has had multiple offenses of the same type in the area at the time. And so I think 0 days. I think I'm going to support Representative Cornish's bill. I'm not going to support your bill, Representative Scott. I think that there are a lot of things that we can do. I just think your bill goes way too far.
Any other questions or comments? Representative Lomer.
Thank you, Mr. Chair, and thank you, Representative Scott, for bringing this bill. And we've had a few conversations about this. And I'm going to support your bill today, but mainly for the reason that I want to move it on to Representative Cornish's committee, and I want to have more discussion. I just feel really uncomfortable with the 0 days as well, but I think it's a good idea to move this on and have more discussion. So thank you.
Any other questions or comments? Mr. Eiling, thank you.
Thank you.
The next testifier, Mr. Gumberling. Welcome to the committee. Please state your name for the record.
Mr. Chairman, Don Gemberling, okay? My children and I have a game we play as to the interesting ways in which the name Gemberling is pronounced, okay? It really is Gemberling. It's pronounced the way it looks.
Sir, duly noted.
Okay, thank you. You're not even close to how bad it can be sometimes. I think my favorite was Gumperdink. How anybody got there, I'm not real sure. So, I'm not going to say much more than Matt has already told you. We support Representative Scott's bill. We support it for the reasons given. The only thing I think I've said this all the way along. I caution you that the thing that Matt said about precedent, I think is very important. You know, we're right in the middle of implementing all kinds of interesting technologies, okay? And those technologies are going to present issues to you. And if you don't develop some kind of comprehensive set of principles, then you're going to be making it up kind of as you go along. And, you know, one of the things that always amazes me about the Data Practices Act, if you're crazy enough to sit down and read the whole thing, is the strange inconsistencies one finds in the statute. So I know the legislature tries to have consistent application of public policy, in part because that's a noble goal, but it also helps the world that you're regulating be able to understand what you're trying to do and why you're trying to do it. So, I'm not going to bore you with a long recitation of technology, but this is this really isn't the beginning, because you have technology-oriented stuff in the Data Practices Act already. But over time, you're going to be seeing more and more discussion about how to deal with technology. And the other part of this, which is like, I'm trying to think of some decent metaphor, but at some point, you're going to have to start trying to deal with the public sector, or the private sector, because that's what a lot of people are concerned about these days. The fact that everything we do on the internet is tracked by somebody. Actually, it's tracked by multiple somebodies. And, without principles, you're going to be struggling with a lot of specific detail. So we appreciate Representative Scott's efforts. We appreciate Representative Cornish's efforts, and we hope you find a decent solution.
Any
Thank you.
questions or comments for the testifier? Seeing none, thank you, sir. Is there anyone from the audience that wishes to testify? Welcome to the committee. Please state your name for the record.
Mr. Chairman, my name is Rich Newmeister. Just in answer to a question that Mr. Chairman, Representative Lesh asked, what's been happening is that when the new technology, an LPR technology came out, a lot of people didn't know about the implications of it. So there were longer periods of time and all that. But since a lot of more research is being done, privacy groups in the communities across the country, there's starting to be a little, what you might call a backlash for more accountability. Even in Congress, there's a talk about having a national regulation of license plate reader technology, Senator Leahy, based on the recent things which you have in your pocket about the DEA and how the sharing on a national level from local agencies, LPR data, up to the feds. Indiana has a bill that's basically saying, just recently introduced, 24 hours you keep it. Then if you want to get access to it, you got to do it through a warrant. The state of Virginia, as best as I can tell, has recently passed a law that says 7 days only, you keep non-hit data basically. If it's past 7 days, it can only be kept for a ongoing criminal investigation. So the trend, if you look across, is there's more buildup, more accountability, and one of the arguments that where you have more accountability is less days. Or you build it up, or you're very specific, or you do a warrant, and it's all over the board. But things are changing. Massachusetts has just introduced a new revised bill because of all the things that people are learning about, and their policymakers are learning about. So I just wanted to put that at least on record of some of the things that are just happening right now. Thank you.
Any questions or comments for Mr. Newmeister? Seeing none, thank you. Any other testimony from the audience? Yeah, Representative Lesh.
I have a technical amendment, if I may. I would like to, on lines 1.12, 1.17, 1.22, 2.2, and 2.6, I would like to strike R and insert is. Because, members, the word data is a collective noun, and there is a trend to pluralize it that we have been back and forth on for years. And unless we want to start saying the water in this building are safe to drink, or the money in your wallet are gone, we should be consistent and change are to is.
And Representative Lesh, just for clarification, could you repeat the numbers again?
Yes, the change, striking R and inserting is would be found on lines 1.12, 1.17, 1.22, 2.2, and 2.6.
Representative Scott?
Thank you, Mr. Chair, and thank you, Representative Lesh. I just wanted to make sure, I know we made some changes from is to R and R to is in statute a couple of years ago. I just wanted to check with House research to make sure that what you proposed was being consistent with that. I don't disagree.
Well, I can answer that for you, Madam Chair.
Representative Lesh.
It is not consistent because there has been a plot afoot for the last 10 years to change everything to R. If you look at the statutes prior to that, unless they've been messed with by people, they all say is. So I'm interested in the traditional way, Madam Chair. Yes. By plot, I mean conspiracy.
Does
I
research-
drink only rainwater and pure grain alcohol also.
Research.
Mr. Chair, Representative Lesh and Representative Scott, I think that description is correct. There has been a trend to go towards data R recently, but I guess it's the will of the committee and how you'd like to grammatically refer to it here.
Representative Scott?
I guess I don't have a problem with it. If there's a problem with it later, I guess we'll be doing a reviser's bill to make the change, but I would leave it for committee members to vote however they see fit.
Representative Lesh? With that said, Representative Scott, Representative Lesh, you make said motion?
I do, Mr. Chair.
One moment. Representative Pinto, do you have a comment before we vote?
Yeah, thank you, Mr. Chair. So I've been looking online at a couple style guides, and it looks like it could be used either way, depending on whether you want to emphasize that it's a unit or a collection of individual items. And it does seem like, in this case, we're thinking of it collectively as a unit. So I guess I would go with Representative Lesh's point. Thank you.
So we have a motion for those 5 lines, are to is. Any other discussion before we vote? Representative Hillstrom.
Thank you, Mr. Chair. And Representative Lesh, have you reviewed this statute that this goes into to confirm that it's consistent with the other sections of the statute that you're placing this in?
Representative Lesh.
Yes, Mr. Chair and Representative Hillstrom, yes, I have, which is why I answered the question that it is not consistent, because parts of the chapter still retain the traditional use of is, but the trend, it's clearly an agenda on the part of certain individuals to change to are. That's a joke. But no, it's not consistent. I'm interested in the traditional way of doing it in opposition to a new trend of moving toward are.
Any other discussion, comments before we vote? Seeing none, we shall vote. All in favor say aye.
Aye.
All opposed, nay.
No.
Motion passes.
The motion passes. With that said, is there any other questions or anyone else from the audience before we close the public testimony portion? Seeing none, public testimony is closed. Any other discussion or comments on the bill? Representative Johnson.
Mr. Chair, Representative Scott, I want to thank you for dealing with this issue. It's a very tough issue that we have to deal with this year because of some of the things that are going on. Although I don't 100% agree with what's in here, I do want to pass this bill on for further discussion because I think we do need to really look at it and we do need to come up with a good compromise because, like I said, we do need to get something passed this year.
Representative Scott.
Thank you, Mr. Chair, and I would just encourage folks to allow this bill to move on to public safety where they have an equal interest in getting the right policy, and I want them to be able to vet both of these bills side by side as we have in this committee. And with that, I'd ask for people's support.
And with that, Representative Scott renews her motion to have House File 155 re-referred to the Public Safety and Crime Prevention Committee. A roll call, thank you, as amended. And a roll call has been requested, so a roll call shall be performed.
Chair Scott.
Aye.
Representative Smith.
Aye.
Representative Applebaum.
Aye.
Representative Grunhagen.
Aye.
Representative Hillstrom.
No.
Representative Hoppy.
Aye.
Representative Johnson. Representative Lesh.
Aye.
Representative Lomer.
Aye.
Representative Pinto.
No.
Representative Schoen.
No.
Representative Vogel.
Aye.
Representative Zerwas.
No.
With the count of 9-4, the motion passes.
Motion passes.
Thank you.
On to House File 222.
Welcome, Representative Cornish. And is there someone that would like to move House File 222? Representative Johnson would like to move House File 222 and have it re-referred to the Committee on Public Safety. Representative Cornish, go ahead. I believe you have an amendment.
Madam Chair and members, we don't have an amendment, but I think you do.
Representative, Representative Cornish, I think you had the DE1 from last time. Are you not offering that? It was submitted again. Were you not going to offer the DE1?
Yeah, I believe it was not the one that we didn't act on last time. We didn't vote on last time. No vote. It was just
That was my amendment from last time, and then it was held over without action, right?
Right. And so
Okay,
would you
I
like to take it
understand
up?
now. Yes, please.
Okay. Representative Johnson moves the DE1 amendment to House File 222. If you want to go ahead and explain your amendment, that would be fine.
Yeah, we want to.
Madam Chair, unless you want us to, I think we walked through that last time, and I would just continue on with the bill.
Okay.
And would you entertain putting up your amendment, then I can react to the whole bill with the amendment.
Okay.
Save us a lot of time.
All right, all those in favor of adopting the DE1, please signify by saying aye. Aye. Those opposed, same sign. The DE1 is adopted. And then, members, I have the DE3, and I would like to do a walkthrough with you on the DE3 that is amended to the DE1. And although Representative Cornish's amendment was an improvement to House File 222, I feel that we need some tighter constrictions on this data, and so that's what the DE3 attempts to do. Representative Lesh.
Could you briefly state, I have been remiss and I am not tracking the changes that Representative Cornish made in the DE1.
Okay.
Could you just briefly state what they were?
Representative Cornish.
I'll turn that over to my testifier, Madam Chair, if you don't mind.
Okay. Please state your name for the record.
Madam Chair, members, the language that was proposed really began to...
Please state your name for the record.
I'm sorry.
Thank you.
Paul Schnell, the Chief of Police for the City of Maplewood, and member of the Minnesota Chiefs of Police Association. It laid out essentially, identified what the systems were capable of, identified the conditions under which and how the data would be classified as non-public. It had the provisions of a 90-day point of retention through which that data could be accessed by the law enforcement agency when there was an active and open investigation. And it had a number of conditions through which law enforcement agencies were required to maintain access logs. Personnel were required to secure authorization in writing prior to accessing the data. It had a reasonable suspicion requirement for accessing the data. And it also had the requirement that we would notify, there would be notification, public notification of the use of the technology and the placement of fixed or stationary units that were put into service throughout Minnesota.
So
those were the essential components.
Representative Lesh.
Madam Chair, thank you, Chief. And so I'm curious specifically about the reasonable suspicion standard that you put in. What kind of hoops do you have to jump through as a chief then to get to that? And how is the written justification saved?
Chief Schnell.
Madam Chair, Representative Lesh, the requirement of reasonable suspicion would be that we would have to have an articulable set of facts that would suggest that the data that we may possess would be pertinent to an active and open investigation, including a case number, and we would need to lay a basis for that. An employee, for instance, an employee or investigator with Maplewood would be required to present that to me or another command staff if they were so designated. Ultimately, I would be responsible as the chief law enforcement officer. They would make the case essentially that the conditions are met, what the case is, and they would identify a kind of a brief factual basis for what it is they are, why it is they need to access this, and how it's pertinent. And we would establish those sets of facts to determine reasonable suspicion.
Okay, Madam Chair.
Representative Lesh.
And Chief, what would the consequences be for a law enforcement official that failed to do that, or maybe got squishy about the facts? Because this is not going before a judge at all, of course, right? So what would happen to that data or that investigation if the procedure were not followed?
Chief Schnell, was that outlined in either the amendment or the bill?
Madam Chair, it was not specifically discussed, although there was provision set in the legislature last year. There was audit requirements that would need to be accomplished with this bill. That I would identify that, number one. Number two is that the accountability measures that were identified by the legislature last year, were there to be wrongdoing on the part of an officer, would be something that they would be subject to.
Well,
Representative Lesh.
Madam Chair, the reason I'm asking is, under the traditional system that we use, if there are either unlawful or unconstitutional actions taken in order to procure certain evidence, the exclusionary rule applies, which means, it can't be used in court. And everyone has dealt with that for 60 years. And so I'm assuming, and the reason for that is, normally it goes before a judge, right? A judge signs off on the warrant, or she doesn't sign off on the warrant. And then if the parameters of the warrant are breached, well, then the exclusionary rule applies. Well, in this instance, there's no judge signing off on it. And I presume it would fall under another standard, what we call in Minnesota as a Rasmussen hearing, to determine whether the evidence has been legally obtained. I'm trying to wrap my head around how it works in this way, if it would just work in the same way, despite the fact that there was no judicial intervention.
Chief Schnell.
Madam Chair, Representative Lesh, I think I understand the issue that you're identifying. I would say, however, that law enforcement officers around this state and around this country are making decisions on the basis of reasonable suspicion every day. And while certainly there have been times when those judgments have been in error or wrong, and to your point, there is or would be mechanisms whereby they could be held accountable and or that data could be excluded in a case through a Rasmussen proceeding, as you suggested or identified. But ultimately, I believe that the provisions that are laid out do provide clarity for why we're accessing the data that would be publicly available, that people would be able to see what was the reason, what were the set of facts that ultimately resulted in the need to secure authorization to access the data that we may have on non-hit data for purposes of attempting to further an investigation.
Great. Well, thank you. Madam Chair, just briefly, and thank you for that, Chief. This amendment then represents, I think, a forward step on the part of law enforcement. I still have some concerns, but thanks, I guess, is what I'm trying to say for offering this. That's all I'll say for now. I'll wait to hear about the rest of the bill, Madam Chair.
Thank you. Representative Johnson.
Madam Chair, Chief, when you first got your LPRs, I take it you had a personnel policy put in effect on how they're properly used. Is that correct?
Chief Schnell.
I assume
Madam Chair, Representative Jensen, yes, we have a policy that dictates how these systems are to be utilized and accessed.
Representative Johnson.
I know I've talked to a number of chiefs, a number of sheriffs that have this equipment, and all of them have policies and procedures put into place And what they've informed me is if there, in response to Representative Lesch's question about people misusing it, when it's in a policy, discipline can be immediate. So it actually works much better than statute, which can take a long time because the assumption of innocence until proven guilty in court. So disciplinary actions could be taken immediately and issue resolved for improper use of the technology.
Thank you, Representative Johnson. Representative Hilstrom.
Thank you, Madam Chair. Chief, could you tell me if they use the search of the non-hit data, that'll be documented in a supplement by the officer, is that correct?
Chief Schnell.
Madam Chair, Representative, yes, that would be fully documented, that what they accessed and whether or not it proved fruitful in furthering the investigation.
Madam Chair. Representative Hilstrom.
Thank you, Madam Chair. And Chief, the defense attorney would get a copy of all of the discovery on whether or not they, how and for what purpose they access that data. Is that correct?
Chief Schnell.
Madam Chair, Representative Hillstrom, yes, they would be provided with full access to all data pertinent to the investigation.
Representative Hilstrom.
Thank you, Madam Chair. And so at some point, if the defense attorney wanted to bring a motion before the court to have that information excluded, they would have the ability to put the officer on the stand to testify about how and why he used that data. Is that correct?
Chief Schnell.
Madam Chair, Representative, yes, that happens routinely.
Representative Hilstrom.
Thank you, Madam Chair. And the judge would have the ability to exclude any of the data that was collected if they felt that it did not comply with office policy or state statute. Is that correct?
Chief Schnell.
Madam Chair, Representative Hillstrom, yes, that is correct.
Representative Hilstrom.
Nothing else. Thank you.
Thank you. Any other questions on the Cornish amendment? Seeing none, I'll begin a walkthrough of the DE3. First of all, on page 1, section 1, it just states that there is an inventory that is required and that inventory will be public. It also covers the definition of surveillance technology. The report requires reporting to be done once a year on the inventory that is maintained and used or may be maintained and used if they're prospectively thinking of purchasing an ALPR or some form of technology. If you go to page 2, there's definition of what an ALPR is and the limitations to the data collected by the ALPR, and those are listed on lines 2.28 through 2.30, and those limitations are the license plate numbers, the date, time, and location data on vehicles, and pictures of license plates, vehicles, and areas surrounding the vehicles. Collection of any data not authorized by this paragraph is prohibited, so it is limited to those specific things. It is also, the data would be classified as private unless but it could be classified as well as active criminal investigative data. And so that also would be non-public data until after the investigation is completed. Top of page 3. There must be additional evidence and reasonable suspicion to classify it as active criminal investigative data. Moving on, under letter C, the agency cannot develop or organize its own data files, nor can it make a centralized repository or develop a centralized depository for all this data. It cannot be used to target or track persons at specific locations without a warrant. And then what this amendment does is it allows for 7 days retention by law enforcement. If you look at line 3.22, some of you know that there's a program called the Safe at Home program, and this is an exemption for that, so that those victims of domestic abuse would not have any of their data made public. Moving on to subdivision 4. In order to share data with another law enforcement agency, a subpoena must be obtained. In the case of the feds wanting any of this information, the data would have to be related to the commission of a crime. Moving on, data from an LPR cannot be shared with, disseminated, sold, or traded with any other individual or entity unless specifically authorized by law. Subdivision 5 talks about the log, that there's a log of use required. It specifies what must be kept in that log of use. And as you can see on page, or on 410, that the list is not limited to just these things, but it can be, it expands to similar categories of information. Let's see, should be a quarterly audit, and that would include, and that would be an independent quarterly audit done by an outside entity. It would audit the records to determine whether the data currently in the records are classified correctly, how the data are used, and whether they were destroyed as according to this section of law. The results of the audit are public, and the audit shows that a law enforcement agency, if the audit shows that a law enforcement agency is out of compliance with the requirements of this subdivision for more than 2 times in a calendar year, 2 consecutive audits, then that law enforcement agency would have to suspend its operation until the legislature authorizes them to continue using it. A report summarizing the results of each audit must be provided to the chair and the ranking minority members of this committee or the committees with jurisdiction over this section of law. For authorization of data, the responsible authority for a law enforcement agency must establish written policies to ensure that law enforcement personnel have access to the data only if authorized in writing on a case-by-case basis by the chief of police, the sheriff, or the head of law enforcement agency. And it tells under those parameters what information must be present in order to access the data. The next section is very similar to the law that we put in place surrounding MNsure, as far as what happens with, no, actually, this isn't that section. This talks about unauthorized access and by an employee. And if the employee is found to be negligent, they could get up to 6 months, or they would get a suspension without pay of 6 months. If they're found to willfully abuse this part of law, then they would be subject to termination. Let's see. The next section talks about the notification to the Bureau of, to the BCA, and that any agency that acquires an LPR technology would have to notify the BCA of what that is, what they've purchased, and within 10 days of installation. Subdivision 10 talks about First Amendment activities and states that an automatic license plate reader may not be used at any event, activity, or assembly subject to the protection of the First Amendment of the United States Constitution without written authorization by chief of police, sheriff, or head of law enforcement agency. And then finally, in section 4, the agencies would have to have a policy, which as far as I know, the ones that do have a policy, or do have LPRs, do have a policy, but it would have to encompass the laws in this section of law. So with that, I know Representative Cornish would like to first make some comments on the amendment, so I'll let him go.
Well, Madam Chair and members, I'm still looking for a way to reconcile this bill. I and law enforcement are totally against the amendment, and we had wished that it be voted down, and I'll go into the reasons why. But I do thank you for the move on retention, but everything else seems like it got buckled down where the bill it'd be completely useless. In fact, if it came to my committee, which it is, I would probably hold it over. The law enforcement's credit, they want to continue working on the solution. I told them to pull this pin on this bill several days ago, because with it, it basically neuters and eviscerates the whole bill with this amendment. I mean, it's worthless. So if it comes into my committee, I would have to change it completely around to suit us, and therefore, there'd be a big fight in the floor. And as we all know, leadership isn't going to let this bill come to the floor if we're not in agreement. So if the amendment is added, I see this as probably an end to the reconciliation of this whole bill. And if I could love to finish the presentation here, it's just that we thought that we were really serious about coming to a resolution and wanted a negotiated agreement. But when you talk about quarterly audits, I'd have to ask research if that's even done anywhere, and how you define the amendment, whether they could set up outside of what you talked about. I don't know how you would define that. The subpoena, the encumbrance are so awful in this thing for law enforcement, the hoops to jump through, that anybody thinking about a system like this would just say no. But all the people that have it, and that's why I say if you pull the bill back, then law enforcement doesn't have the audits. They don't have the log books. They don't have the hoops to jump through. They don't have any of this thing. So I'm giving credit to law enforcement for sticking in this game to the end, because without a bill, which there wouldn't be if we can't come to an agreement, they've got everything that they wanted, save the protection of the privacy if we put that on again. So I'm kind of at a loss of what to do, because if the amendment passes and comes to my committee, it's a non-starter out of there. So can I go through the points here that the bill now?
Certainly.
We do thank you for the move in the retention, but such a short retention period really limits the technical, the capabilities for law enforcement. And it was said that there is a state that went to a 7-day retention period recently, but I say to that, so what? I actually believe the retention periods are going to get longer, because the more this system is used and the more major cases it's solved and found out how valuable it is, I think the retention periods will get longer. The only reason I think it was such a short retention period is admittedly LPR data hasn't been out in the public eye a lot. When they found it, and then certain people say, and I'm not saying you folks, but Armageddon is going to happen and the sky is going to fall in, they look at shorter periods. Once they realize what the bill does and the capabilities we have of solving crime, I think that the actual retention periods will get longer. And to take one state and say they passed a 7-day retention period, that's the lowest in the nation. It's almost unheard of. I mean, Texas has the death penalty. Are we going to model our state after that? So to cherry pick one state out and hang your hat on the short retention period, we don't think is really fair. And we've talked to you folks about crimes reported a week or a month or a year after they occur. That's why we need the longer retention period. The warrant lines, we feel it's unreasonable to ask law enforcement and the courts to issue a warrant to view a license plate on a vehicle on a public street. The only difference there's some differences between this system, but an officer can enter literally hundreds of license plates into the MDT right now on a check on a given night. Now you're talking about basically the same system and having a warrant. The annual audits, we support annual audits. Our idea was once in every 3 years. We thought you folks might, come down to 2 years or 1 year, but I mean 4 audits a year? It just seems totally unreasonable. It seems to me that some of the advocate groups sensed that we were coming close to a reconciliation on the time, and they got so worried about that, they decided to kill the bill by adding other things once the retention period was going to be better, because even if you gave us a 30-day retention period, all of these things makes the use of the technology so encumbersome. The disciplinary lines of 513 and 525, we support the law that took effect in August of 2014 that makes unauthorized access of a government database a criminal offense. We wonder why we didn't mirror that instead of jumping into disciplinary actions at a local level, why we didn't just take up something similar to that. The sharing of the ALPR data, the sharing among the police agencies is critical to solving crimes quickly, and we support safeguards, including a legit law enforcement purpose or reasonable suspicion. The administrative subpoena, I think with all that, is not necessary, and it's just one of those hoops, again, that I think that we have to jump through. The centralized ALPR database, In order for this to be effective, there's got to be a centralized database that stores license plate numbers of vehicles that have been reported stolen and wanted in connection with a crime such as Amber Alert. And the BCA currently provides such a database, and we support that in continuing. This was a Senate floor amendment last year and wasn't intended to be in the initial draft language. And then there's a section here about drones in your... I didn't even want to go ahead.
Yes, Representative Cornish, that's on the first page, and that's just in the definition of surveillance technology. That's the only reference there.
And the whole drone thing, I didn't even plan on hearing anything about that in my committee. You're addressing that, and it kind of just gets in a little bit that other people are going to jump onto that anybody that wants anything done with a drone once we enter that into the language. So, Madam Chair, I don't know how we fix it because it's put in a DE1 amendment. If there was in separate amendments, I appreciate the movement on the retention period, but everything else here takes away any attractiveness in the bill for me that had, even with the short retention period. So I don't know where to go from here, because if, like I say, if the amendment's defeated, then you're not going to be happy, and we're not going to come to a resolution because we have to have this on the floor. And so I don't know how to address this. I'll leave it up to you folks how you want to play this out.
Representative Cornish, before we move to member questions, I'd like to hear from members of the public on the DE3. Quickly, if anyone would like to have any words about it. Go ahead and introduce yourself for the tape, please.
Madam Chair, for the record, my name is Rich Newmeister. One has to take a look at what is the basic issue here. You've got interest, privacy, liberty interest, new technology. Law enforcement wants to use this technology. Secondly, we also have to take a look at the history in Minnesota of how law enforcement has abused some of its authority that it's had just in the last decade. Whether it be MJNO, where millions of records were kept on many citizens in a private organization. Number two, GangNet, thousands and thousands of people were just put in a database, which is now closed. The whole issue of DVS. And there are other kinds of things happening locally, statewide, and nationally where people are saying there needs to be accountability. This is what this bill, the DE3 amendment, does. And first of all, the Privacy Commission has been very strong to say, hey, what's out there in the community? What's out there? And so one of the things is the inventory. This is an attempt to get an idea of the kinds of technology that's out there. The DE3 amendment is a lot of the same language that's in the DE1, which is basically from the Senate. And there are some changes. The definition is truly the definition that should be used from all data collected from these devices, rather than a defined definition, what you have in the proposal. One of the other things that I think is important is that, Madam Chair, as Representative Johnson indicated, he saw on his ride-along on how people were putting things in their own little type of database, or he came to that point of view. So what 3.6 through 3.10 says, you're only going to use the database, the data file that's currently under law. People know what's being put in there, and there's an exception, except the locals can do their own if someone is being investigated. On lines 3.9 and 3.10, a central state repository. In Maryland, in California, in other places, they're doing centralized databases on innocent, non-hit scans. This is not the centralized about databases. This is on keeping millions of scans on innocent, law-abiding people of where their locations, and with those pictures, those kinds of pictures that have been part of the testimony. 7 days, it goes off, to where there's some movement. Secondly, some of the quarterly audits, I think, are important, or some type of audit. Quarterly is one of those things, and that can be used, for discussion. I have no problem with the subpoena. in the issue of where, on the First Amendment rights, we are already aware that LPRs are being placed at gun shows, protest rallies, churches, whatever it may be. It's very, very clear what First Amendment activities are. I think it's important, and that type of policy is very similar to St. Paul's surveillance policy that they adopted several years ago, that there needs to be a sign-off.
Madam Chair?
And
Quick question for Mr. Neumeister on that point.
Representative Lesh.
Thank you. Before I ask a question, Mr. Neumeister, he was just speaking about the First Amendment activities, subdivision 10. Can you tell me, how did that language come into the DE3 amendment?
Representative Lesh, that was a concern of mine because I knew that, that this had been occurring, if not in Minnesota, other places where law enforcement was scanning the license plates at gun shows and those sorts of activities.
Okay. And thank you, Madam Chair. The question I was going to ask is, how we, how that works, because the First Amendment is a prohibition against prior restraints, and I don't know how we anticipatorily, maybe you can answer Mr. Neumeister, how would we anticipatorily determine that an assembly is protected by the First Amendment in light of the fact that the First Amendment is simply a prior restraints prohibition? And if you just want to bypass and say wait for the lawyer, that's fine too.
I'll wait for a lawyer, but I'm trying to do some common sense.
Or Mr. Neumeister.
Madam Chair, Representative Lesh, for me, I just look at it from a common sense perspective. LPRs have been used at demonstrations, at churches, whatever, across the country. And possibly here, I don't know. And so it's just like when law enforcement observes or they infiltrate public meetings or things like that, which is recently with the Bloomington MOA. Generally, some departments, what they have a policy. It says if law enforcement has to do something with a First Amendment activity, generally, there has to be some accountability to that. And all I'm saying is that I've seen when law enforcement has been observing political rallies with the RNC here in Minnesota, in St. Paul, there's a lot of policies. They were even sued over that recently, and they've come to some policies, at least in St. Paul that I've seen, where there needs to be some authorization before there's monitoring of First Amendment activities.
Well, and Madam Chair, the reason I'm asking is I think this language is potentially workable. I hear Representative Cornish's statement that he has concerns about it, and I think I see why based on my question. But there's probably a way to work through that, because I have some of the same concerns. I wonder where you can park a reader to get a whole pool of individuals that you think are doing something wrong when you don't have individualized suspicion. And I wonder if the DE1 amendment has taken care of that, to the extent that if law enforcement is surveilling a pool and they happen upon something that they weren't looking for, based on that articulable suspicion contained in the document they just said they're going to submit, then any evidence collected based upon that surveillance is gone. It's out, because it's fruit of the poisonous tree. So I wonder if that isn't enough of a safeguard against it being used in the method that you stated. Do you think it's not?
Mr. Neumeister.
Madam Chair, Representative Lesh, I'm not going to answer. I got to think a little bit more on that. Madam Chair, if I may just finish on just a couple more points. One is, there was discussion. When you set one of these cameras, which is rising with technology with facial recognition features and other kinds of things, in front of a house for a specific person or a location, there is a privacy interest. And that's where some discussion, states, whether it's statutorily or by case law, are starting to say privacy interests are expanding. And so I think there should be a warrant in a particular place if you're going to use this kind of technology, particularly as it advances. One of the other things, again, little differences in this amendment. when you're talking about audits, then the DE1, it doesn't say audit how the data is used. It's basically, is it classified or some other thing? One of the important things is when you do audits, you want to take a look how the data is used. And so that's another little word that's placed on this section. So, Madam Chair, for Representative Cornish, he's very much entitled to his opinion. And I've known Representative Cornish for decades. And him and I go back and forth. I help him on some things. He, on another point, believes on some things. He helps, you know, we exchange views. But he knows that this is a big issue. And I think I hope, is open to some of these kinds of things rather than just dismiss the whole bill or the whole attempt to try and, for some accountability, transparency, as these two strong interests are butting up against each other. So, Madam Chair, members of the committee, I encourage you to continue on to adopt this amendment and continue on with the discussion.
Thank you, Mr. Newmeister. Anyone else in the public wishing to testify? Mr. Gimberling. Go ahead and state your name for the record, please.
You bet. Madam Chair, Don Gemberling from Minnesota Coalition on Government Information. If I remember correctly, the inventory of surveillance technology, which is in Section 1 of the DE3, was in the original bill, if I remember. And at the time, I think we said that this is a good thing. As we go into the advanced era of surveillance technology, part of what I've come to believe is you can kind of limit the abuses with greater transparency, okay? Are there going to be abuses? Well, history tells us, yes, there are going to be abuses. But to the greatest extent that the public knows how law enforcement is using technology, the better off we're going to be, and the better off you're going to be able to make decisions, okay? So having an inventory, for example, is a good example of that. I'm not going to go into a lot of technical stuff in the bill. Frankly, you know, even though we've supported zero retention from day one, we know, number one, that's not practical, and number two, it's not going to sell. So is 7 days a reasonable compromise? It's a compromise, let's put it that way. And I wish Representative Leschko, he's right there. The First Amendment thing in subdivision 10, that kind of language appears in other states' laws limiting the collection of that kind of information. Now, frankly, off the top of my head, I can't give you one of those states, but I know in the 40-plus years I've been doing this, I've seen that kind of language, and it's usually in some kind of law limiting the government's collection of information about First Amendment activities. There is the possibility, given Representative Lesch's concerns, that it could be fixed a little bit to make it clear that what you're trying to prohibit is the use of technology that's trying to surveil the exercise of rights under the First Amendment, okay? You know, and that exercise includes the right of free speech, the right of assembly, the right to petition the government, and the right to exercise religion, okay? Without governmental interference and hopefully without governmental surveillance. So, you know, we're going to support any kind of compromise that's reasonable, but of course we're all going to disagree about what is reasonable. And I think this is another attempt to come to a compromise. And we appreciate your efforts.
Thank you.
If you have any questions, I'd be happy to answer.
Okay. Doesn't look like anyone has any questions. Anyone else, member of the public, wishing to testify? Go ahead and state your name for the record, please.
Madam Chair, members of the committee, Jim Franklin, Executive Director for the Minnesota Sheriff's Association. Specifically with the DE3 amendment, we do not support it. There are a number of problems. I would just point out a few things that I think are problematic in the language and how we implement it. If you go to line 1.8, if you talk about personal characteristics, as an investigative officer and detective, I would use Google and I would search from my computer a person's name to try to determine information that may or may not be relative to my investigation. Under this bill, in terms of inventory, my computer potentially at my office becomes something that we would use in tracking purposes. It also talks about Facebook and activities of an individual. I mean, if I go on Facebook and all of the other kinds of things in my investigative duties, would that then comply? I talk about property of an individual. If you have real estate transactions or other kinds of things that you can track electronically, all of these kinds of things, is that technology covered under this inventory that we as governmental agencies or entities would have to report? I would also draw your attention to surveillance technology on line 115. The way I read this, as you know, we use surveillance technologies in jails all the time. Building, public works buildings, the Capitol. The way I read this, we will all have to file annual reports on all of the cameras, all of the technologies that we use in all of our governmental entities, jails and everything, every year for every change that we come in with. There's a number of other things in here. 7 days is a movement. Obviously, we want more time. We have a double-edged sword in law enforcement. We need to prove somebody did the crime. We need to exonerate people that they are not involved. And so as we go through and look at this bill, there's issues, and some of these have already been highlighted, and I won't take up any more time. I just want to alert you to the fact that we have concerns about this bill. Be happy to go into much more detail, but I think in the interest of time, I'll just conclude with we're not in favor of the DE3 amendment.
Thank you. Anyone else wishing to testify? Okay, first of all, I think Representative Schoen, you were first on my list.
Thank you, Madam Chair. So how much do these quarterly audits cost?
Representative Schoen, I don't know.
Madam Chair, who's gonna do them?
That's up to law enforcement to find someone to do them.
So, Madam Chair, our local governments are gonna be forced to pick up the bill for quarterly audits, and they're gonna have to hire somebody, some random private entity to come and do quarterly audits on private data?
Representative Schoen, the amendment that Representative Cornish had an audit every 3 years, do you think that that's adequate?
Madam Chair, I do. I support Representative Cornish's bill, and 3 years seems adequate. And that's
so
the
Representative
compromise,
Schoen-
but quarterly is burdensome. I mean, that is unheard of.
Representative Schoen, you are aware that in the past, law enforcement has abused the law by looking at innocent people's data, mine included in that. You're aware of that. And had the audits been done more frequently on that, maybe it wouldn't have gone on for so long. So, quarterly may be tough, and maybe we'll land somewhere in between. But once every 3 years is not adequate. It's a non-starter.
Well, Madam Chair, when you say that maybe audits would have done it well, quite frankly, when you're talking about the driver and vehicle services website, you're talking about a different thing. I understand where you're coming from, but, we've taken steps to make sure that the access to that data after the fact is protected more than it was when it was first brought out. And so the steps in DVS have taken the right direction that they've needed to. And we're trying to do that here about saying, here's how you can access it. That's the important part. Quarterly is just, if you're gonna do something like this, then there has to be remuneration from the state, because that's an unfunded mandate at that point. All I will say is, if you don't want license plate readers, then introduce the bill to ban license plate readers.
Madam Chair.
Representative Lesh.
Madam Chair and Representative Schoen, I think we need to remember where we came from here. Because the suggestion that, oh my gosh, our hands are being tied, why don't you ban license plate readers? If we were talking about hit data, that would be one thing, okay? The express statement is we want license plate readers to take care of all the work cops had to do in tracking hit data that they used to have to do. But this entire conversation for 3 years now has been about the non-hit data, which was not available unless cops were taking those little Post-it notes in their squads, handing them off to the secretary down at the office, and they were hand entering them into a database, which was not happening. So the 99% of the stuff we're talking about is the non-hit data, and that is a significant new either tool or concern, depending on how you want to look at it. And I just think it's a lot more complicated than said, well, we want to ban license plate readers, because I know that for me, that's not true. The technology is out of the barn, it's going to be out there, but some of these safeguards, I think, should have a reasonable conversation, and I think what Representative Scott is offering as an amendment is legitimate. And you might be right. You know, quarterly, wow, administratively, it's going to be impossible. I could be persuaded on that, but I still think the conversation is important.
Well, Madam Chair, Representative Lesh, I mean, not that I always agree with Mr. Franklin, but I mean, that's a great point on all our cameras and everything else. Everything is under surveillance. I mean, it's not just license plate readers that may affect. That goes a whole different direction.
Representative
So
Jones.
I don't know what the answer is here. I mean, at this point, if you're a non-starter and he's a non-starter, then let's vote on this and kill it here then, and call it good, and just let it be what it is, what it was going to be without legislation.
Representative Johnson.
Madam Chair, I have a question for Mr. Franklin. Still happens to be here.
He is. He's coming forward.
Mr. Franklin, on lines, on the DE3 amendment, on lines, basically it's 4.26 and 4.27. I'm just wondering if you're aware of any legislation ever passed or even introduced in the past where a law enforcement agency, because of a small error in a inventory or audit, lost their ability to use a piece of equipment until the legislature authorized them by statute to be able to do it again.
Mr. Franklin.
Madam Chair, Representative Johnson, in my 40-plus years of doing this, no.
Representative Johnson.
Thank you.
Representative Hillstrom.
Thank you, Madam Chair. I'll ask for a roll call.
Thank you. A roll call has been requested. Any further questions from members? Members of the committee? Representative Hoppe.
Madam Chair, I was just going to ask for a point of clarification. Are we still on the DE3 amendment, or are we?
Yes, Representative
Okay, thank
Hoppe.
you.
We're still on the DE3. Members, the intent of my DE3 is to put some really tight guardrails on use of the information. And as Representative Lesh said, most of this is because information is being gathered on innocent people. The hit data is one thing. The non-hit data is a completely different matter. When we're collecting information and it's in the hands of in the hands of law enforcement on innocent people. And I'm certainly willing to work with Representative Cornish going forward, and I hope that I have, maybe I should ask him to come to the table again and just get his word on record that if I withdraw the DE3, that we will move forward. We'll pass his bill as it is amended with his amendment, but that's not the final word on this subject.
Madam Chair, before you bring Representative Cornish to the table, Madam Chair, in the event that any of these provisions get amended into Representative Cornish's bill, I would assume that the bill would be coming back to this committee so that we could take a look at these data pieces. And Madam Chair, even if you withdraw this amendment, I think I probably will reoffer it because I think this committee should take a vote on these issues if we're going to see it again.
Madam Chair.
Representative Lesh.
I think it's important to proceed in good faith here on this and not just draw lines in the sand. That's how we got 3 years into this in the first place, Representative Hillstrom. So I understand your passion on your side of the issue. I equally have as much passion on my side, but I don't think lines in the sand are a good measure at this point. I like what Representative Cornish and law enforcement has brought forward today with the DE1. I think it's worth further discussion, but so are the provisions that are contained in your amendment. So I would ask Representative Hillstrom, please reconsider the roll call piece.
Representative Hoppy?
Thank you, Madam Chair. And I would like to say, we passed your bill. I think you're making a wise decision to keep working on this issue. I mean, clearly, this is not a partisan issue. Clearly, this is a contentious issue. Lots of testimony in for and against, lots of questions for and against from the table. I think that the truth is we're going to come up with something that's going to be somewhere between the bill before us and your amendment. So thank you, and thank you, Representative Cornish, Hillstrom, Lesh, everybody. Thank you all. Thanks. Appreciate it, Madam Chair.
Representative Cornish.
Madam Chair, if you withdraw the amendment and pass the bill out in the present form, I guarantee you that I have no intention of putting a bill out of my committee that you definitely disagree with, because I think that it'll never come up on the floor if that's the case. So I would be very interested in working with you in law enforcement and get everybody together, and especially, if we got time for like 3 minutes to run over the changes that have taken place, or do you rather?
We're done at 10, and I know Representative Applebaum has a question, so.
Just a couple of bullet points here. I just
Okay.
wanted to reemphasize the changes we made since we started out to now with the
Okay.
present bill. Go ahead.
Go ahead, Mr. Potts, introduce yourself.
Madam Chair, Jeff Potts, the police chief from Bloomington, and just to kind of highlight a couple of things. So we came into the session with plenty of things that were yet to be agreed upon, and just to kind of highlight, 222, the D1 amendment does do a few things that had not been done prior to the session. 90-day retention, that is in the bill. That's not something that would be in law prior to the session. Reasonable suspicion for access of the data is something that did not exist before, agreeing that, to try to calm the issue or calm the concern about the data existing and putting in place proper protections, identifying good protections, I think, is key to doing that versus just not holding the data. Our citizens really do expect us to be able to solve those cases and those victims, as we're talked about. That data is helpful. So audits, the bill that is in front of you says 3-year triennial audits. I think in our group, we can agree that maybe there's some middle ground between that and quarterly. Quarterly is very tough, but we didn't have requirements for audits before. So requiring an audit, requiring the agency to articulate a reason for searching the data is a big step forward in that area of terms of trying to protect the data. Policies and procedures didn't exist before this session. So restrictions on access to the data didn't exist before this. I think we've come a long ways in terms of trying to come up with a compromise that really does protect the data, but also allows law enforcement to maintain the tool in solving these crimes. There are really good protections, and I think in the D1 that didn't exist before today, before this session.
Thank you for that. Representative Applebaum, you have a question.
Thank you, Madam Chair. No, it's just more of a statement, really. This is the third informational hearing we've had on these issues, and I really think that we should address it here as arbiters of the LPR program, and the rest of the House looks to us for guidance on it. And although I voted on zero retention before, I mean, I think and while there's some certainly some good ideas in your amendment, Madam Chair, I mean, structurally, I just don't think it's right, and I believe that it would indeed die, and in that case, I mean, passing no law in relation to this issue would be a travesty. So that's just my 2 cents. Thank you.
Thank you so much. Further discussion on this new plan. I will withdraw the DE3 in good faith with Representative Cornish with the promise to work on some of these finer details of the bill. And with that, any further questions from members? Representative Hillstrom.
Thank you, Madam Chair. Madam Chair, I believe that this has some significant issues, and I believe that this is the proper place to deal with these issues. So, Madam Chair, I will offer the DE3 amendment, and I would ask for a roll call on it. Madam Chair, I think this has significant problems. I think this is the committee to address them in, and I think we should vote it down.
Madam Chair.
Representative Lesh.
To that point, I don't think that that is a good faith effort. When the chair has stated, Representative Hillstrom, that she's going to withdraw it, but in order to get a hash mark in your column, you want to jeopardize a negotiation process. So I would remind committee members that they are not required to take a vote on a roll call if they don't want to, and I won't be taking one.
Representative Hillstrom.
Thank you, Madam Chair. Representative Lesh, in our rules, it specifically says that when someone offers an amendment, that any member of the House can re-offer the amendment, even if the amendment is withdrawn. If Representative Scott wanted to, in good faith, proceed with negotiations, one of the things she could have done was offer these amendments to her own bill to keep it in place. She passed it on. Look, we have 2 bills on the same issue that are proceeding, and it's time that this committee take a stand on where we're going to end up. I think it's appropriate, and I think it's well within the rights of any member to offer any amendment. I think it's a bad amendment, and I don't think that the good faith negotiations have necessarily been going on, and therefore, I'm offering it, and I'm asking for a roll call. And if people don't want to vote on it, they can choose to take a pass.
With that, members, we are recessed.